Hello everyone, welcome to LBS IAS Academy. Today we are going to discuss polity MCQs based on previous year UPSC questions. So let's start our session. Our first question is,
5-year plans in India was finally approved by options are Union Cabinet, President on the advice of Prime Minister, Planning Commission and National Development Council. Here answer to this question is option D, National Development Council, that is NDC. NDC was the final authority that used to give final approval to the 5-year plans. The 5-year plans have paved the way for rapid development of the Indian economy. There are 12 5-year plans that have been made in India, and 12th 5-year plan was the last plan of India. The decades-old 5-year plans have been replaced by 3-year action plan, which will be part of a 7-year strategy paper and 15-year vision document. The Niti Aayog, which has replaced the Planning Commission, is the new body that gives policy direction. Its founding principle is cooperative federalism. Most important difference is that Niti Aayog has no power to grant funds or make decisions on behalf of states. It's only an advisory body. So here answer to this question is option D, NDC.
For election to Lok Sabha, a nomination paper can be filled by option A, anyone residing in India. Option B, a resident of the constituency from which the election is to be contested. Option C, any citizen of India whose name appears in the electoral roll of a constituency. Option D, any citizen of India. The answer to this question is option C, any citizen of India whose name appears in the electoral roll of a constituency. The Parliament has laid down the qualifications for contesting election in the Representation of People Act 1951, which includes the candidate must be an elector in the constituency. The minimum age for becoming an MLA or MP is 25 years. At the Panchayat and municipality levels, the minimum age limit for contesting election is 21 years. The candidate cannot be nominated if they have been convicted for some offences and are in prison. So here answer to this question is option C.
Which one of the following articles of the Indian Constitution provides that it shall be the duty of Union to protect every state against external aggression and internal disturbance? Options are Article 215, Article 275, Article 325 and Article 355. Here answer to this question is option D, Article 355. Article 355 entrusts the duty upon Union to protect the state against external aggression and internal disturbance, to ensure that the government of every state is carried on in accordance with the provisions of Constitution. So your answer to this question is option D. Which one of the following rights was described by Dr. B.R. Ambedkar as the heart and soul of the Constitution? Options are right to freedom of religion, right to property, right to equality, right to constitutional remedies. Here answer to this question is option D, right to constitutional remedies. Right to constitutional remedies under Article 32 is a fundamental right. It was called the very soul of Indian Constitution and very heart of it by Dr. B.R. Ambedkar. In other words, the right to get the fundamental rights protected is in itself a fundamental right. This makes the fundamental rights real. That's why Dr. B.R. Ambedkar called Article 32 as the most important article of the Constitution, an article without which this Constitution would be a nullity. The Supreme Court has ruled that Article 32 is a basic feature of the Constitution. Article 32 states that individuals have the right to approach the Supreme Court seeking enforcement of fundamental rights recognized by Constitution. So here answer to this question is option D, right to constitutional remedies. The term of Lok Sabha, option A, cannot be extended under any circumstances. That is incorrect. Option B can be extended by 6 months at a time. That is incorrect. Option C can be extended by 1 year at a time during the proclamation of emergency. That is correct. Option D can be extended for 2 years at a time during the proclamation of emergency. That is incorrect. So here answer to this question is option C. Under Article 352, while a proclamation of national emergency is in operation, the life of Lok Sabha may be extended beyond the normal term for 1 year at a time. However, this extension cannot continue beyond a period of 6 months after the emergency has ceased to operate. So here answer to this question is option C, can be extended by 1 year at a time during the proclamation of emergency.
If a new state of the Indian Union is to be created, which one of the following schedules of the Constitution must be amended? Options are 1st, 2nd, 3rd and 5th. Here answer to this question is option A, 1st schedule. The first schedule contains the list of states and union territories. Hence, it must be amended if a new state is created. There are 12 schedules in the Constitution of India.
One of the first mentions of schedule was made in Government of India Act 1935, where it included 10 schedules. Later, when the Indian Constitution was adopted in 1949, it consisted of 8 schedules. Today, with the amendments in the Indian Constitution, there are a total of 12 schedules. The Supreme Court of India tenders advice to the President on matter of law or fact. Option A, on its own initiative. Option B, only if he seeks such advice. Option C, only if the matter relates to the fundamental rights of citizens. Option D, only if the issue poses a threat to the unity and integrity of the country. The answer to this question is option B, only if he seeks such advice. Article 143 of the Constitution authorizes the President to seek the opinion of the Supreme Court in 2 categories of matters. First is on any question of law or fact of public importance which has arisen or which is likely to arise. Second is on any dispute arising out of any pre-constitution treaty, agreement, engagement or other similar instruments. In the first case, the Supreme Court may tender or may refuse to tender its opinion to the President. But in the second case, the Supreme Court must tender its opinion to the President. In both cases, the opinion expressed by the Supreme Court is only advisory and not judicial pronouncement. Hence, it is not binding on the President. He may follow or may not follow the opinion. Therefore, Article 143 provides for the advisory jurisdiction of the Supreme Court. So, here answer to this question is option B, only if he seeks such advice. The 9th schedule was added by which amendment? Options are 1st, 9th, 35th, 36th. Here answer to this question is option A, 1st Amendment. 1st Amendment Act 1951 empowered the state to make special provisions for advancement of socially and economically backward classes, provided for the savings of laws, providing for acquisition of estates, etc. 1st Amendment added 9th schedule to protect the land reforms and other laws included 18 from judicial review. Freedom of speech, acquisition of zamindari land, state monopoly of trade were the causes behind 1st Amendment. So here answer to this question is option A, 1st Amendment. Which article of the Constitution provides that it shall be the endeavour of every state to provide adequate facility for instruction in mother tongue at the primary stage of education? Options are Article 349, Article 350, Article 350A, Article 351. Here answer to this question is option C, Article 350A. Article 350A in Part 17 suggests instruction in mother tongue. It shall be the endeavour of every state and every local authority within the state to provide adequate facility for instruction in mother tongue at the primary stage of education to children belonging to linguistic minority groups. So here answer to this question is option C, Article 350A. Which one of the following schedules of the Constitution of India contains provisions regarding Anti-Defection Act? Options are 2nd schedule, 5th schedule, 8th schedule and 10th schedule. Here answer to this question is option D, 10th schedule. The 10th schedule of Indian Constitution talks about anti-defection law, which is designed to prevent MPs from switching political parties for any personal motive. The anti-defection law was passed by Parliament in 1985 and reinforced in 2002. The anti-defection law was enacted to ensure that a party member does not violate the mandate of the party, and in case he does so, he will lose his membership of the House. The law applies to both Parliament and state assemblies. So here answer to this question is option D, 10th schedule.